minutes.
Your Lordship, Ms. Amritananda Chakravarti, Your Lordship, I'm a petitioner just after Ms. Karju.
Yes.
Yeah, I'll just take 10 minutes, Your Lordship. Very brief. I've already given my note, my lords. It's volume 8. It's a brief 1.5-page note, Your Lordship. I've set out my...
Got your note. If you can just make maybe 1 or 2 points now.
Yes, Your Lordship.
What is the...
Your Lordship, I have challenged certain provisions of the Foreign Marriage Act and the adoption regulations. I'm the only petition that has challenged the adoption regulations for excluding same-gender couples and transgender persons from the institution of adoption, joint adoption specifically. Why have I challenged adoption regulations? Before that, Your Lordship, I just want to say that the petitioners, they have been in a relationship for the last 15 years and they have married under the Denmark law on 16th of August 2022. So we are a couple who is married under a foreign law and we are living as a married couple in Germany. And what we want, we are there because of our professional deputation. We don't want to settle abroad. We want to come and settle in India. But we want with our marital status, we want with our joint life that we have built in Germany. So the question on Foreign Marriage Act, I just have one point, Your Lordship. Your Lordship has my note?
Yes. Why don't you formulate it?
Yes. My first submission under the Foreign Marriage Act, Your Lordship, is, if not for my sexual orientation, the petitioners would be able to register their marriage in India under Section 17 of the Foreign Marriage Act. And what is that exclusion, Your Lordship? That is not, if I may respectfully submit, under inclusion, Your Lordship, that is discrimination simpliciter. To exclude a couple on the ground of sexual orientation, that you are treated as a married couple in Germany and in...
Yes. Point is 40 years.
So that is discrimination simpliciter. My second point on adoption regulations. Your Lordship, I've set out the adoption regulations in my note.
Yes.
B. If I may read, Your Lordship.
What's the point on the adoption regulation?
That my point is the adoption regulations go beyond the remit of the Juvenile Justice Act. If I look at Juvenile Justice Act, Your Lordship, the definition of prospective parents in 249 of the JJ Act, it uses the word person or persons. Your Lordship, if you may look at the JJ Act just for 1 second. 249, Your Lordship. My laws, Justice Kaul and Justice Bhatt has it. The JJ Act 249, the definition. If I may read.
Yes, read please.
Prospective adoptive parents means a person or persons eligible to adopt a child as per the provisions of the Section 57. Please mark these words, Your Lordship, a person or persons. Now, if I may come to Section 57. Your Lordship, please note JJ Act is a secular legislation that has been said by my learned predecessors. This is not, I'm getting into personal laws. This is the only law which we had brought in adoption from the Hindu personal law into a secular legal regime. Your Lordship, if I may read Section 57, Clause 1. The prospective adoptive parents shall be physically fit, financially sound, mentally alert, and highly motivated to adopt a child for providing a good upbringing to him. Clause 2. This is the relevant clause, Your Lordship. In case of a couple, the consent of both the spouses for the adoption shall be required. Then 3 is a single or divorced person can also adopt, subject to the adoption regulations. 4, single male is not eligible. That's not relevant. I am on 57.2. My first submission, Your Lordship. Marital status of a prospective adoptive parent is not a relevant factor to determine the eligibility of adoptive parents, including for joint adoption, which is my Roman 3 in my note. If we look, as we had seen, the definition of prospective adoptive parents, or Section 57.2, where is the word married here? If the Parliament wanted to restrict joint adoption only to heterosexual married couples, because married is not just married couple. As of today, as we have seen in the last 2 weeks, it is heterosexual married couples. Which couple can marry under the Indian law at present? If the Parliament wanted to restrict joint adoption under the JJ Act Section 57, it would have used the word married. but it doesn't. It uses the word couple, it uses the word spouses. Yes, it may be said that as per the Indian law, couple and the spouses is a heterosexual married couple, but that is not what the legislation says. So how can the adoption regulations, now if I may read adoption regulations, your lordship, regulation 52A, which I have challenged, any prospective adoptive parent, it is set out in my note point B, irrespective of his marital status and whether or not he has his own biological son or daughter, can adopt a child subject to the following, namely A, the consent of both the spouses for the adoption shall be required in case of a married couple. Regulation 5.3, no child shall be given in adoption to a couple unless they have at least 2 years of stable married relationship. Where is this word marriage in the JJ Act, your lordship? And even your lordship has held, Chief Justice Justice Chandrachud, in X versus Ministry of Health, marriage is not a precondition to the rights of individuals, whether alone or in relation to one another. Your lordship, I will not take you to the judgment. It is in the common compilation. But I am emphasizing on this phrase in para 40 of the judgment, X versus Ministry of Health. Marriage is not a precondition. So it means even this principle has to be applicable to the point of joint adoption also. Marriage is not a precondition to the rights of individuals, whether alone or in relation to one another. I'm emphasizing in or in relation to one another. Just take the example of the petitioners, your lordship. I am a married couple in Denmark. I come to India. My marriage is not recognized. I am dealt as two single individuals who are stranger to law. I cannot even go for joint adoption because of this regulation, which is not borne out from the text of the law. My next submission, your lordship, is restricting joint adoption only to heterosexual married couples amounts to discrimination on the ground of sexual orientation. Why am I saying this? Because one can say that yes, even unmarried heterosexual couples can also not adopt jointly. But they have the option to marry under the Indian law. But a same gender couple or couple involving a transgender person, they do not have the option to marry. So in effect, what the adoption regulation is doing, it is essentially restricting joint adoption only to heterosexual married couples. And that, in my humble submission, is discrimination on the ground of sexual orientation. And I will show your lordship from the CARA circular, which is on, if your lordship, compilation 2 documents, volume 2, if your lordship want to look at it, that is a circular dated 16th of June, 2022. And I will show how that circular even bars me in my individual capacity. That is in compilation 2 documents, PDF, volume 2, PDF 459, sorry. Your lordship may please look at it. Compilation 2 documents, volume 2, PDF 459. This one document I want to show your lordship. It's a CARA circular dated 16th of June 2022. And that will show the sheer absurdity, because it fell from the lordship last week that a lesbian woman can adopt in her single capacity. Okay, you might not be able to adopt in your joint capacity, but you can adopt as a single person. Now I will show.
16th of June.
Your lordship has it, the circular? Volume 2 in documents, compilation 2, volume 2, documents, page 459, PDF page 459. Justice Bhatt and Justice Kaul has it?
Yes.
You read
Your
it
lordship,
here.
if I may read, just 3 lines. It's an office memorandum from Central Adoption and Resource Authority. Registration of cases of single PAPs, prospective adoptive parents, that is, having a live-in partner in a long-time relationship and not married regarding. It has been noticed from home study reports that some single PAPs registered with CARA for the adoption process are in relationship with their live-in partner. The cases of single PAPs engaged in live-in relationship have been discussed in the steering committee of Central Adoption Resource Authority held on 18th April 2022. It has been decided to go with the earlier decision of 14th, I'm not reading that, then after 10th May 2018, that the cases of single PAP in a live-in relationship with a partner will not be considered eligible to adopt a child, and their registration from concerned agencies, authorities will not be considered for approval. Then point 3, this is the main line. The decision has been taken in line with Regulation 5.3 of the Adoption Regulations 2017, which is exactly the Adoption Regulation of 2022, 5.3. The authority would like the children to be placed only with the stable family, and single applicant in a live-in relationship cannot be considered as stable family. Your Lordship, this is the Kara circular, which is barring even a single person who is in a live-in relationship from being eligible to adopt a child. All this while we have been thinking that a single person, a single queer person, a single lesbian person can adopt in their single capacity. What is the harm? You have access to adoption. But I don't. And where is this coming from? It is referring to Regulation 5.3. So just look at my state. I am married in Germany. I come to India. I am treated as a stranger in law to each other. And now I cannot even adopt in my single capacity because I am in a relationship with my partner. I am, in fact, a married couple as per foreign law. So as per the Indian law, as per the adoption regulations, I am not even thought fit to be eligible to apply in my single capacity. What is the effect and what is the messaging to the queer community? Your Lordship, my last point. My predecessors have talked about right to found a family. I'm saying right to motherhood. I'm a lesbian couple. I have been desiring to have a child, to adopt a child, as much as I desire to have my relationship recognized. Now, last point, Your Lordship, it is not just the right of a adoptive couple to a family. It is also the right of a child to a family. We are talking of adoption, and as per the JJ Act, who is to be adopted? If we look at Section 56 of this right has been statutorily recognized. If I may read, Your Lordship, Section 56(1), adoption shall be resorted to for ensuring right to family for the orphan, abandoned, and surrendered children. These are the children we are talking, Your Lordship, orphan, abandoned, and surrendered. And they have a right to family, not just under the JJ Act, under the international law also, under Convention on Rights of Child, Article 20. The exclusion of same-gender couples and transgender persons from adoption defeats the very purpose of adoption, defeats the very essence and the object of adoption, which is what? Which is to provide a stable, a loving and affectionate family to a child. Just because I am part of a same-gender couple, just because of my sexual orientation, I will be denied this basic right, not just to myself, but even to a child who needs a loving family. And lastly, what Ms. Karju said, Your Lordship, the entire JJ Act, what is the guidance of this JJ Act? It is in the best interest of the child. Is it in the best interest of a child not to have a legal relationship with the second parent? Is this how we are going to advance the object and the purpose of the JJ Act? I rest my case, Your Lordship, with just last point that the petitioners, they are part of a historically oppressed and discriminated minority. Their relationship and their family deserve as much dignity and recognition as it is to be accorded to an opposite sex couple. I'm really grateful, Your Lordship. I'm really grateful.